Is the lens cap off?
This is GRL Raw, the podcast where the GRL team tells you why they're different. Who the hell are they? Why should you want them fighting for you? The industry leader in law with over 180 years of combined experience. This team is here to shed light on crucial topics in law to keep you aware and informed, because it comes back to the primary point. We give a damn.
Welcome to Season 2, Episode 6 of GRL Raw. I am joined, my name is Bobby, in case nobody figured that out by now, and I am joined by none other than Matthew the Wolf Lindholm.
Hey.
Is that what wolves say?
That's what this wolf says today, because I'm a little confused after all of this homework you had me do leading up to this episode.
You know what I appreciate about you, though?
Do tell.
You took homework and you went next level with your homework.
I did. You were worried, but I did.
I was cussing you out until I realized that you actually did put together a flow chart over this entire topic.
I did. See, I mean, it's an actual flow chart because it is necessary.
And you added to your flow chart.
I did. I added some notes.
Do you think you can turn that into one of those bracelets like in football that they wear that people can look into their plays and say, under Division 1, I think we can shoot. Division 2, no shoot. 3, run and shoot. Get it? Run and shoot.
I mean, anything can be done, right? But it might be tough.
What are we talking about today?
We're talking about reasonable force.
Reasonable force.
Otherwise known as justification. So what would be commonly referred to as an absolute defense to some type of assaultive behavior, murder, attempted murder, those types of things.
Can we use some buzzwords?
Of course.
Stand your ground.
Stand your ground is what is, I guess people are probably commonly referring to it now as, in light of the legislative changes back in 2017.
The Castle Doctrine.
The Castle Doctrine. Yeah.
And really what brought this topic to our attention was there was literally 7 cases in 7 days across the nation involving incidences where people were shot either on doorsteps, in vehicles, in situations that really drew public scrutiny.
Yeah, it hit mainstream.
Kids.
It hit mainstream. You've got cases involving kids. You've got cases involving police officers. You've got, I think there was at least one case involving an intoxicated intruder or what was perceived to be an intruder but was actually just the wrong house.
A drunk kid.
Yeah.
With the wrong apartment.
Exactly.
Okay.
Exactly.
So I'm debating whether we roll with the golden quote, which we skipped last episode, but we have a golden quote that fits perfectly in this if we talk about that now or after our historic Iowa case.
Well, it's your show, so you run it how you want.
It's not my show. It's not my show. I've been told that multiple times.
Well, I mean, I think people like gold, but maybe we should go through the historic case and make them listen a little bit before we get to the nugget.
I like that.
Yeah.
I appreciate that.
All right.
Because it's your show today.
Well, I am your guest. It's still your show.
Not my show.
Our
GRL
show.
Raw, not Ray Kemper Raw. That would be a whole different. We don't want to go there.
I don't even want to
go
think
there.
about
no.
that.
Historic Iowa case. Next. Okay. Historic Iowa case. We have done every episode thus far. We've talked about historic Iowa cases. We kind of cheated last episode and talked about the police misconduct with Dodovic, Octavius Bonds, case that we actually were involved with back in the day. This is an old school, actual Iowa historic case that we got to read our first year in law school. Did you guys read this one in Creighton? I know you guys are a little subpar.
Yeah, no, Creighton does have law books and cases in them, much like Drake. So, yes, we did read this case and probably read it before all you smart people at Drake got to it. So
I think so.
Yeah, we're ahead of the curve at Creighton.
Till it falls off. You stayed there, didn't you? Oh, wait.
For a year.
For a year. Okay, what's the case name? What's it called? What are we talking about?
Katko versus Briney.
Okay.
Right?
Katko with a K.
With K.
Katko.
Right.
Corey's favorite case.
Yeah. Should have had one here.
We should have had the cat. What is this case about? And it's back. I think the actual events happened in 1967. The opinion didn't come out until 1971. Give us a nutshell Twitter version of Katko versus Briney, and why is it even important?
Sure. It was a case that ultimately was a civil case. Somebody was suing for damages because they were injured. Briney had an abandoned farmhouse that had been subject to frequent burglaries, and they were taking things like fruit jars and old whiskey bottles and that kind of thing. So he decided that despite this house being abandoned for a pretty significant period of time and boarded up, that he was going to set a trap in the house for these intruders.
Which part of the great state of Iowa did this happen in?
Oh, that's a damn good question.
Here, hold on, I got you.
Oh, Mahaska County. I'm not sure why that's relevant, but apparently it is.
Well, because we like to set the scene, buddy.
Okay,
like
fair
this,
enough.
this is Southern Iowa at its finest.
Where is Mahaska County, Bobby?
Southern Iowa.
Where?
Exactly. Oskaloosa.
Bingo.
They have O's. It gets confusing.
Right.
Yeah.
So anyways,
O-town.
this abandoned house in Oskaloosa, Mahaska County, was booby-trapped. And
Can you say that?
I just did.
It is GRL
and
raw.
It was booby-trapped with a spring gun.
What's a spring gun?
It is a contraption whereby you set up a gun or something that will fire a projectile, and when you open the door, it pulls the trigger, activates the gun, and discharges.
It's like a tripwire to a gun.
Yeah, think Road Runner and Wile E. Coyote kind of thing.
So a boulder from the cliff?
Kind of. Did you even get to watch cartoons growing up?
No, and we don't need to talk about that right now.
All right, so
It's rude.
This was rigged so that one of the upstairs bedrooms, when the door opened, the gun would discharge in the direction the door was open. So somebody coming into that room would be hit by the discharging firearm upon opening the door.
And to be clear, this farmhouse was abandoned, boarded up, not inhabited. Nobody lived there.
And hadn't for quite some time, which is important to the analysis, that nobody was present monitoring this residence when this spring gun was set up.
Mr. Briney was just tired of those darn kids breaking into his farmhouse.
Correct. Mr. Briney thought that because it was his property, he could take whatever means necessary to defend that house and the property in that house.
I don't think he's alone in that.
No, I mean, a lot of people think that, and right or wrong, unfortunately, that's just not the state
Don't ruin it.
of
Don't ruin it.
our
Hold it.
show
Hold. Yes,
topic
there you go.
for
Good change.
discussion
Good
right
change.
now.
So boarded up, booby trapped, second floor, bedroom, Briney,
So Katko and his accomplice decide that they're
cold stormy night.
possibly
Okay.
in
Cold
Mahaska
stormy
County.
night in Mahaska County, Oskaloosa.
So Briney and his accomplice Katko and his accomplice decide that they're going to go get some fruit jars. And
Everybody
lo and
needs fruit
behold,
jars.
they enter the upstairs bedroom where the spring gun is, and bang, Katko's leg disappears.
So unlike Wile E. Coyote, the booby trap worked,
The booby trap did work, yes.
and it blew up Katko's leg.
Rather significantly, to the tune of, I think, 40 days worth of hospitalization.
It was bad.
Is bad. Yeah.
Even back then, bad.
Right.
Not
Yes.
suburb soft bad. This was legit
Yep.
blowed up.
Yep.
Okay.
In fact, I think the opinion goes on to talk about how it was so significant that if there wasn't an accomplice there with him to help him get out, he would have perished. So.
Okay. Ended the fruit jar thieving.
Yeah, no more taking of the fruit jars. So,
Okay. So what happened?
Ultimately, Katko turned around and sued Briney for the damages he sustained, and basically said that, you caused a battery on me, and therefore I'm entitled to damages because of what you did.
But he was the one breaking and stealing crap. He was breaking in, like they were boarded up. Like he literally had to take boards off, break in to try to steal himself some fruit jars.
Yeah, true.
And nobody has fruit jars in the bedroom.
Apparently not those. I mean, not those kind. I
no.
don't know. Yeah. So anyway, Briney gets sued by Katko. Briney turns around and says exactly that. I was justified. It's my property. I can do whatever I need to defend my property, including setting up a spring gun to blow somebody's leg off if they enter my property.
Seems excessive.
Well, the Supreme Court thought so.
They did, didn't
Yeah, they did. They ultimately said, no, that's not justification. And they kind of put out this, maxim that human safety is...
Hold on, Corey. What's a maxim?
I'm sorry. It is a statement, so to speak. That Rule.
Okay.
That human safety is higher in value than somebody's property.
Okay.
So they said you cannot use what was considered, I guess, deadly force in that particular case to defend property.
Makes sense.
Yeah, I mean, it conceptually it makes sense to some people. Conceptually, it won't make sense to some people.
Some people are like, no, you break into my stuff, I should be able to do whatever I want.
Yeah. You're committing a crime. I should be able to take whatever means necessary to stop that.
And you're committing the crime, so why should we care?
Exactly.
I get it. Yeah.
Yeah.
So was this the first spring gun case in Iowa?
No, there was another one.
Here you go, buddy.
The name of which I'm not following your notes here. Oh, Miller. Yes, Hooker versus Miller. And it was from Vinton.
We know Vinton.
Yeah, we do know Vinton.
Can we pause real quick?
Benton County. Yes.
We have to give kudos to the good people of Benton County.
Yes, because those fine, reasonable folks up there in Vinton, Benton County, actually, not just Vinton, Benton County, just recently said that our client should get a nice award from a employer that had caused some.
An employer was irresponsible, put an employee in a very dangerous situation. The employee tragically was killed, and Benton County returned a verdict total in the entire case of over $3 million.
Correct.
Corey had that case. Melissa was up there helping with them.
Yep.
Big deal. We love Vinton. We love Benton County. Phenomenal job out of them. And in that case, though, the Hooker case was in 1873.
That's right.
And what were they protecting in Benton County in 1873 with a spring-loaded tripwire shotgun?
Grapes, I think, right?
And they got to protect the vineyard. So vineyards in Iowa are not a new bougie thing. They actually go back to 1873 in Benton County. They were growing the crap out of some good wine grapes back in the day. But it was fun reading that case again. So in law school, you read it, focus, and like Professor Albert is yelling at you, just give me the guts, give me the meat. I just want to know what it is. But when you read the case, you find out Ohio had Iowa beat.
Yeah, I don't know the particulars of that case, but yeah, I know there was one from Ohio.
They booby-trapped with dynamite. Ohio went dynamite. And they said
spring gun, dynamite, they both go boom.
They do both go boom. And then Texas said, no, Ohio, you're not even doing it right. We're going to go straight bomb. They put a bomb to protect their property.
Boom, boom, boom.
Boom, boom, boom. And each court said, no, you can't do that. You can't blow people up to protect property. Life is more important. Life is more valuable than property. True?
Yep. That's exactly what they said.
Now, we can't leave this alone because Donut would be disappointed if we didn't add extra facts.
Okay.
From Wikipedia.
You mean besides Mahaska County?
Yes.
Okay.
And me not knowing the town, but it started with O-Town. It was O-Town.
Okay.
However, according to Wikipedia, there was some after facts that we learned post Supreme Court.
Yeah, there were.
Most importantly, Mr. Briney was not apologetic.
No, he was not. In fact, I think he was asked at one point in time, if you could do something different, what would it be? Or
Yeah.
And his response was, I would have aimed the gun a little higher.
Savage. And the interesting part is in the facts of the case, they talk about how his wife actually convinced him to aim the gun lower to shoot the legs instead of the person in the gut.
Right. Right. And then there was a whole big deal with the neighbor and selling his land to pay the judgment, and then the neighbor didn't ultimately want to sell it back. So then he actually, I think, joined forces with Briney in a civil suit, or with Katko in a civil suit against the neighbor about this land. So it's really bizarre.
It was Southern Iowa Special.
Yeah, probably.
I can't say that. Yeah, we just did. Sorry. But before okay.
But that's probably not the most intriguing fact of that case.
What's the most intriguing fact of that?
At least to me, the most intriguing fact was that after all of this, Mr. Katko took his own life in his front yard with a gun, which is bizarre.
That's like a bad episode of like.
I know, it's just strange.
Hey, historic Iowa cases with GRL Raw. We go the extra mile. Which brings us to the golden quote that factors into this whole justification. So this is a case that we reviewed on a civil side, and I'm going to set it up for you, and you get to throw the quote out. Okay, you ready for this?
Okay.
You've watched the video.
I think I know what you're talking
Remember about homework and me being worried about homework being done?
Well, you wanted to talk about reasonable force and what the Iowa law says, so that's what I prepared for.
Okay, so we got you on that. You ready? So, this case, we got asked to review a shooting case, and the tragic results were that it was terrible for the family of the individual who was shot. It happened in the Drake neighborhood. But we find golden nuggets everywhere and things that you just are never going to forget. And I will never forget this because it was a shooting in a convenience store in the Drake neighborhood. And we were on it. We were investigating it for the potential civil liability on the convenience store, whatever else may be. And we sent requests. They produced videos. These videos have audio in them as well. And what we observed, to me, is still, if I can ever find this guy and buy him a few beers, I'm going to do it, okay? Because what happens is at this convenience store, there's initially a fight in the convenience store. You can see it all on video. Some guy comes in, they're mouthing to another guy inside the store, and they fisticuff in there. Another day in the Drake neighborhood. Guy leaves, another car comes back. And what happens is there's the guy who was in the fisticuffs still in the store talking to some employees, and somebody shows up at the door of the convenience store and is talking crap through the glass door, those doors to get into the convenience store. And not just talking crap, pulls up his shirt and then ultimately pulls a gun out.
His piece, yep.
He pulls his piece out and is talking shit through the glass to the individual inside. At the same time this is happening, a gentleman is at the counter of the convenience store. So this is the guy who's getting crap talked to him. This is the crap talker outside the door. This is the counter. Our hero of this story is sitting here buying, I don't even know what he's buying, but buying something small from behind the counter. This is going on, driving, talking crap, blah, 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 gun gets shown, and the guy behind pulls out his gun, aims, pop, pop, pop. 3 shots through the window, hits this guy. This guy at the store is wrapping up his transaction. The first shot gets fired. I'm not joking. Everybody behind the counter dives. They swan dive. They scatter as I would. I would have been curled up in a cupboard somewhere. You're not finding me for an hour. This dude.
Cucumber. Well, let's call him Cucumber.
Cucumber.
Cool as a
cucumber. Cucumber stands there, bags his own stuff, looks back at this guy, does not flinch, looks at what just happened, and utters the golden quote of this episode, which is what?
Shouldn't have been playing. I mean, he's a cucumber.
Cucumber.
Yeah.
Shouldn't have been playing.
Nope.
And then walks out the door, steps over, and goes on about his day.
Yep.
Cucumber. I bet Donut can make us some shirts that say shouldn't have been playing.
Or just cucumber.
Ooh. I don't think we will. No. We'll go.
You know, we could put Donut on it. We could call it Digging with Donut and see if she can come up with this guy and see if we can get him. That would be fun.
That would be amazing.
Yeah.
That would be next level.
That would be next level.
I mean, we already talked about footage of us doing our self-promoted,
And
self-manufactured.
we could have a beer with him on camera. Have a discussion with him. That'd be cool.
I'd be in.
Me too.
If he watches the podcast, Cucumber, call us.
I wonder if Cucumber's still alive. There's a chance he's maybe not.
He's too cool not to be.
Suppose.
Okay, but this is the perfect segue. This is the first time we've had the golden quote of the month that actually segues into our substantive topic.
Oh, now we're going to get to my flowchart.
Now we get
Okay.
to get to the
Sweet.
Wolf's flowchart about stand your ground, justification, self-defense, castle law, all that stuff. When and how is Cucumber justified in that situation?
Yeah, that's that would be. It would take a pretty significant legal analysis because there's some missing pieces to that puzzle. You know, you don't know if Cucumber knows the guy behind him. You don't know what was being said through the door. I mean, there's a lot of things a lot of facts that might have some bearing on whether or not that was a justified shooting.
Remind us to circle back around and finish with
Will do.
the end result of Cucumber's story.
Fair.
Okay.
Okay.
So in getting ready for this, we did some research. I did some Googling, as I tend to do. Wikipedia is my favorite. This did not come from Wikipedia. But so a lot of the current events that brought us to talk about this involve shootings. One in particular was in Missouri, where the young black teenager was on the porch, and the old guy, the guy was like 84, shoots him with a shotgun through the door or something like that.
They all start to run together. There's been so many of them. I'm not sure where it was.
But clearly, and then
I don't think it was Mahaska though.
it was not Mahaska County. It was south of Iowa. I'm going Missouri. I'm calling it Missouri. But I started looking into this, the whole stand your ground, castle doctrine, and I wanted to blame a lot of this on the legislature and what they've been doing because I get a little annoyed personally, and I want to vent and reach out, but I don't think the more I looked at it, we'll talk about it. But we found these quotes from a website as it relates to stand your ground, and I want to ask you if these are accurate under Iowa law. Okay? The first one is, residents occupying a dwelling or other structure may employ force, including lethal force, in defense of themselves and any others occupying a dwelling, so long as they are responding to a forcible or surreptitious unlawful entry into the occupied dwelling. Is that standing alone accurate under Iowa law?
Yes, generally. And here's the problem with this is, you know, when you start to break this down, and I understand your frustration with the legislature to a certain part because this got labeled stand your ground, right? And that sends a message to people that you don't have to back down. You can stand there and use lethal force, deadly force, and it sends kind of the wrong message that it's okay whenever. And that's just really not the state of the law.
That's not the state of the law.
It is not the state of the law. There are some things that changed with the legislation in 2017. And ultimately what it was, for the most part, was this duty to retreat. And do you have a duty to retreat? And the answer is generally no, you don't have a duty to retreat so long as you're not involved in a crime.
Can we set some basic ground rules, though, and basic definitions? First of all, what is deadly force?
Sure. So deadly force is, commonly use of a gun, use of a knife, use of any type of weapon that reasonably could cause serious injury, and it's being used with the intent to cause that serious injury. Discharging a gun is deadly force. So it's the legislature has defined it as an act or actions that or reasonably should know creates a strong possibility of serious injury. Now, I don't know where you draw the line between what's strong and what's not, but that's how they've defined it.
Okay. Can we say that shooting somebody is deadly force?
Yes.
Like
that's safe to say.
Stabbing somebody?
Yes.
Hitting them with a machete?
Yes. Baseball bat.
Baseball
yes.
bat.
Car, probably.
Car
Yep.
for sure.
Yep.
Okay. And in general, if we're going to have one hard and fast rule as it relates to justification, what is the minimum requirement for use of deadly force in Iowa?
Only the amount necessary to dispel of the force or threat that is being used against you or somebody else.
Okay. So if you're afraid of me, as you should be, because I'm tough, and you are afraid I'm going to punch you. I'm saying I'm going to punch you, Matt. I'm going to knock you out. Can you shoot me?
No, because I know it's not reasonable for you to be able to knock me out.
Okay. That aside. That aside.
No, it's not. I might be able to, hit you first. I might be able to, do something that is one step above you hitting me, as long as I reasonably perceive or believe that you're going to actually do it.
But I mean, if we're saying the best rule as it relates to use of deadly force, what would you say that best rule is? You have to have a reasonable belief of
imminent death or serious injury to you or somebody else.
Okay. That's an easy to apply rule across the board. Well, it's a guideline. It should be easy.
Yeah. Can I back you up for
Please.
a second? So this made it easy for me to kind of wrap my head around and conceptualize this topic. You've said justification, and that's kind of a legal definition that not a lot of people maybe truly understand or appreciate. Let's talk reasonable force.
Yes.
Reasonable force, right?
Yep.
Because that kind of encapsulates and instills the message that we should be talking about here. So what force is reasonable under the circumstances? And Iowa has kind of divided that into two. So you've got deadly force, and then you've got other, is how I'll describe it. So, you want to go the deadly force path, there's a whole bunch of things you've got to go through to get there.
Uh-huh.
If you go other force, it ultimately really just comes down to, was it reasonable under the circumstances?
Common sense.
Common sense.
No doy kind
Yes.
of stuff.
Right.
Okay.
Right. Now, the one thing is a lot of people think that there is an automatic get out of jail free card because of the stand your ground law. So if I use deadly force, I will not be charged, and my case will not ever get to a jury.
I will not have to worry about being convicted and going to prison.
Right. And that just isn't accurate. That's not accurate. Ultimately what it comes down to is an investigation done by the police, and there's a determination made as to whether or not the amount of force used, whether it's other force or deadly force, was reasonable. And if a prosecutor thinks that wasn't reasonable, they're going to charge. And your case is probably going to get to a jury, which is scary because a jury could say, yeah, I don't think it was reasonable either.
Correct. And I don't think people appreciate that. A lot of times people are just talking about, well, if somebody steps on my yard or somebody breaks into my house, I'm going to blast them. And I'm going to be just fine. There's nothing that can be done to me. And that's not necessarily the case.
Yeah, it's not necessarily the case. There's, as to every rule, there's exceptions, and there's quite the exception paradigm to go through here.
Well, let's go through it. Let's talk
Let's do
about
it.
the Wolf spreadsheet.
All right, let's do it.
Break it down. So
you want to talk deadly force, right?
We're talking deadly force. So reasonable force, like if you got to defend yourself, defend somebody else with non-deadly force, that's a whole nother discussion. And really it boils down to what's objective under the circumstances, how reasonable is the force used, and do you stop? Good rule of thumb in non-deadly force, if you knock somebody down, you're good, you're done. If you dispelled the attack, you're done.
Right.
Back off.
Right. Well, before we get there, though, let's back up again. Hypothetical for you. So you're pumping gas. I'm pumping gas next to you. You see I'm from Mahaska County, and obviously you don't like Mahaska County.
They use spring guns.
Yeah. And so you start talking trash to me when I get out of my car. And lo and behold, you start coming at me with a knife. And I stand up and I pull my gun and I say, stop, and I point it at you. Is that deadly force?
Pointed at me?
Yep.
No.
It is not deadly force.
No.
Nope. Because I haven't discharged the gun. Pointing it, brandishing it, showing it is not considered deadly force.
Is it a threat of deadly force?
It's the threat to use deadly force, yes.
So I could put my knife away or ninja star you,
Right.
and I'd be justified.
Not necessarily, because then we got this thing
Provocation.
called provocation.
Son of a biscuit.
Yeah, it's tricky.
Let's talk about home invasions.
Yep.
Because the other one we talked. I read that quote from that website, and then that website ends up with, in short, so long as a citizen is defending themselves from an aggressor who is making a forcible or surreptitious entry into an occupied dwelling, they are presumed to be possessed of a reasonable fear of death or great bodily injury, and the use of lethal force in defense is justified. My concern is with that last statement, but let's unpack. Let's talk about home invasion, because Katko versus Briney involved invasion of a non-occupied structure. But let's say I hear somebody tinkering around in my house.
Yep.
And I've been trained by Mad Dog Madison here in our office. I know how to shoot. I know how to carry. I know how to do all that stuff. Somebody walks through my door, and I smoke them.
So you're talking, this is where you live.
My residence.
You're there when it happens.
I'm there.
And somebody comes into your house.
Yep.
And
My dog does not wake up.
Did
like
they-
he doesn't.
did they
He
just
does. People, he does. He's
open the
ferocious.
front door and walk in?
Yeah, I don't. I didn't lock my door.
Okay. So the analysis under that is
Quietly opens my door though.
okay, it's got to be a dwelling.
Check.
It's got to be a place of business or employment
Or
or an occupied vehicle.
okay, so if it's my dwelling.
Yep.
That
So
checks that
we
box.
check that box.
Okay.
Okay. Then you've got to figure out, was the person entering that place through force or stealth?
Quietly open my door. Stealth.
So possibly, I'm not sure. Courts haven't weighed in on that, but possibly. Let's check the box for now.
Okay. But there's an argument that it wasn't stealthy and I could be in trouble.
I suppose, yeah.
Okay.
Because your door's unlocked.
True. Lock your door, people.
And unlawful. Right? It's got to be unlawful.
I didn't invite them.
Okay.
Rando, don't know who they are.
Now,
Not even going to say it's a
Okay.
guy. It's a they.
is the person entitled to be there? Is it a roommate? Nope. Is it somebody that lives with you?
Rando
Is it-
from the streets.
Okay.
Don't know him. Not invited.
All right, so
Never
we're
mind.
checking off boxes. We've
Yep.
got a dwelling. We've got, we'll assume stealth or force. We'll assume that they're not entitled to be there. And then the question becomes, is there any type of crime you're involved in, or are you using the dwelling for any type of criminal activity?
Hold on. What does what I'm doing in my own house have anything to do with me being able to shoot this person?
Well, because the legislature has said that if you're involved in a crime, when you use the deadly force or the location in which the deadly force is used is being used to perpetuate a crime, you're not entitled to that presumption that the use of the deadly force was reasonable. So your criminal activities negate that presumption.
So I got to know if I'm involved in a crime.
Yes.
Or if I'm...
Yes.
So, like...
I know that might be hard because you started at Drake and I started at Creighton. I would know if I was involved in a crime.
Would you?
I would.
What if you were in contempt because you had your kid at home, say you're divorced, which would ruin my perfect streak of officiating weddings and people living happily ever after. But say you got divorced and the children were at your house in violation of the visitation order, and you were in contempt. Like you had been held in contempt because you didn't return their medication to mom in time. Okay?
Okay, I think.
Is this making sense? There's a court order.
Okay.
You're supposed to divorce. This is where it's going to get messy because divorces, all that kind of stuff. You're supposed to give something back that you're not. So you're in contempt of court.
Okay. All right.
Let's assume you're in contempt of court for violation of an order.
I was going to make it a little easier and something that maybe is a little more.
Fine. I tried.
I know it's terrible, but
You're the wolf.
it's my show.
It's your show. Run with it, buddy.
So let's assume that as this person's breaking into your house, you're sitting there smoking a Fat J
What's a J?
joint,
What's that?
bowl, weed, marijuana,
Oh, dope Yoda stuff.
dope Yoda stuff.
Okay.
So let's assume that you're doing that as this person is breaking into your house who doesn't have a lawful right to be there and has done so with force or stealth.
That's probably a better example than mine.
If you shoot that person, you do not get the presumption that the use of the deadly force was reasonable. Because you're involved in a crime. However, if you've got a medical marijuana card in that situation, it might change that scenario.
So there is a presumption. There is a presumption that exists in the law. If you're not breaking a law, somebody is breaking into your house and you shoot them, and everything else being the same. If you're not breaking the law, at the time you shoot them, there's a presumption that you were justified in using that force.
Let's just boil it down and make it very basic.
Please.
You're asleep at night. You hear something in the kitchen. You grab your gun. You go out. There's an intruder there. You know that the window's broke or the door's kicked open. You know that person is not supposed to be in your house. Mm-hmm. If you shoot that person, you better be damn sure you've shot them in the front and not in the back, and that they're in your house in order for you to be able to get that presumption.
Does the presumption require you shoot him in the face as opposed to in the back, though?
It doesn't, but if you want to have no questions in the case, it better be that way.
Does that prevent a charge from being filed?
It does not.
So you could still be prosecuted based upon the prosecutorial discretion or their evaluation of the circumstances. They could say, you know what, this is a jury question. This is something a jury should decide. We're going to let them decide if the wolf was justified in shooting this guy.
Yeah, I mean, let's remember, prosecutors have the luxury of being able to present whatever facts they want to a judge to get a charge approved, right? So they could leave out specific information
and establish reason to believe.
Right, and the charge gets approved, and then we look at it and we say, no, this was a justification. The problem at that point is the Supreme Court has said we don't get to go in front of a judge and have the judge determine that this charge should be dismissed if we can present those facts. That's the scary part about it.
But there is a presumption if somebody is secretly breaking into your house and you're not otherwise committing a crime, if you use deadly force, there is a presumption that you were justified in doing so.
Correct.
It does not preclude a charge from being filed, but it is a
not.
presumption that goes with you through that case in defending the charge.
That is correct.
Good to know.
Yes.
Okay. That presumption can be countered.
It can. Yeah.
Which is where you're saying you better not be shooting them in the back as they're running out the door.
Right. Yes, because it's just a presumption. So what that means is there would be, when the jury gets the case, there would be a jury instruction that says you are entitled but not required to presume that a person who shoots an intruder into their house is justified in using deadly force. Now, the state can come back and show whatever other facts that might exist in the case to show that that wasn't necessarily justified. For example, the person's like, I'm sorry, man, I'm drunk. I'm in the wrong house. I'm leaving. You shoot that person in the back as they're walking out the door, you're probably not going to you're going to have troubles.
Because it still boils down to, is there a reasonable belief that your life or somebody else's life is in jeopardy?
Yeah, ultimately it boils down to that, yes, at the end of the day.
Okay. So that's the home intruder.
Yep.
That's a good bet. And so a couple of set rules that we do have is you can't use deadly force to protect property.
Correct.
You can't use deadly force when you know or have reason to know that your life or somebody else's is not in danger.
Correct.
Okay? So law enforcement, you can't use deadly force because somebody's not complying with your orders.
Right.
Can't shoot somebody because they didn't drop to the ground and put their hand behind their back like you ordered them
Right.
to. Okay? What's some other pitfalls that exist as it relates to the stand your ground, self-defense, justification, castle law, whatever we want to call it?
Sure. So, I guess there's also this presumption that gets created if somebody is attempting to remove a person unlawfully from a dwelling, place of employment, or occupied vehicle.
Okay, so we have the burglar presumption.
We got the intruder presumption. Let's call it the intruder presumption.
Okay.
And then we've got the kidnapping presumption, so to speak.
Okay, tell us about this kidnapping presumption.
So what the
Because
legislature...
I'm seeing this as being problematic.
It could get ugly.
Yep.
So what the legislature has said is that you kind of start down this road of going to this presumption again, that your use of deadly force is justified if somebody is unlawfully taking a person from a dwelling, place of employment, or occupied vehicle against their will. There's a couple exceptions, but that's the general gist of that rule.
What are the exceptions? Because I got questions.
Yeah.
And I'm guessing the exceptions might answer my questions, but it's your show, so tell me the exceptions first.
So one of the exceptions is if the person who is being taken is a child, grandchild, or otherwise is in the custody of the person who's trying to take them. So let's think about this.
See, so my messy divorce
that bingo
example
goes
that
better
didn't
here.
work
Right.
goes better here.
So
Okay.
we have the situation, divorce, children in the middle, parental exchange at Target, right?
Mm-hmm.
So dad
You
is...
do parent exchanges at Target?
Well, I'm using that. I mean, do you want to use Mahaska County?
Yeah,
You can do that. Okay,
please.
so parent exchange in Mahaska County.
Law enforcement center.
At the Briney house.
I don't know. I want to go there, but okay. Whatever you say.
So-
It's your show.
So this exchange goes down, right? But dad was supposed to do it on Saturday, pursuant to a court order.
Right.
Exchange has to happen on Saturday. Dad doesn't do it till Sunday. Okay? Mom comes and...
It's my day.
Right.
Okay.
And gets an argument, of course, with dad because it's supposed to be back on... Child's supposed
Is
to be
there
back on
drinking?
Sure. It's
Mahaska County?
Sure, drinking.
Okay.
They drove there. One of them drove there drunk. Mom drove there drunk.
Allegedly.
Actually, dad drove there drunk.
Allegedly.
And mom gets in the car and attempts to forcefully remove the child from the car.
Okay. This happened a lot,
Right.
unfortunately.
Is dad justified in shooting mom?
I'd say yes, according to the rule that you just told us.
Okay. But the exception is unless it's a child, grandchild, or somebody else the parent has lawful custody of.
We don't have lawful custody if it's not his day.
it's not Dad's day, it's Mom's day, it's Sunday.
Right, so mom had every right to take the kid out.
Right, so Dad can't shoot her.
What if it is his day?
So that becomes a little more messy because then you have this.
Can we stop right here? Don't
shoot.
Don't shoot
Mom
your
for-
ex-spouse over children, especially with children present.
Right.
Ever. Just don't shoot people.
Because there becomes an issue of, all right, well, what is custody, right?
Yeah.
I mean, because a lot of times in divorce proceedings, the judge will award joint custody, right, with a visitation schedule. So technically, you both have legal custody of the child. So if either one of you tries to take the child from the other, there's an argument that you had legal custody so the other parent wouldn't be justified.
I understand what the legislature was trying to do. They did a really crappy job.
It could have been done better.
Should have been done better.
Should have been done better.
Regardless, let's not shoot each other over custody arrangements, please.
Right. But you still also then have another layer of exceptions there, which is if you're committing a crime. So if Dad drives there intoxicated.
Oh, Jesus. Here we go.
Let's say Dad drives to Target and has custody of the kids and is intoxicated, and a stranger tries to grab the kid out of the car, right?
Shoot him.
Dad shoots the stranger.
Yeah. No problem.
If Dad's impaired, he's committed a crime by driving the car there impaired, and therefore does not get the presumption that he was justified in using reasonable force. Now, that doesn't mean a jury is going to say he wasn't justified, but he doesn't get the jury instruction that instructs the jury that
there's a
it's
presumption. But there is an additional justification that exists. We'll call this the third rule, Wolf's rule of justification, related to forcible felonies.
That is true.
What is that?
That is true.
See how I served that up there? We rolled that right in.
So
It's
the
not even in
legislature has said that if you may use reasonable force, including deadly force, to prevent the commission of a forcible felony.
Okay.
Or to stop the commission of a forcible felony.
So I have a question. And I know that Creighton Law is an esteemed institution.
Oh, I'm not going to get all the forcible felonies. I'll try, but go ahead.
And I know that Drake Law is an esteemed institution of educational betterment in the legal community. Did you have to, as Matthew the Wolf Lindholm, look up, research what qualifies as a forcible felony for purposes of talking about this today?
I did. I did not write them all down. I don't have them all memorized, but I can give you a list.
I appreciate that, but my point is, you've been practicing law for how long?
20 plus years.
20 plus years. Same.
Yeah.
I had to look up and we practice in criminal defense.
Right.
That's kind of our jam. The NFG, it's on the back. NFG would tell you about that. We had to look up what qualifies as a forcible felony.
Right.
How is normal Joe or Josie supposed to know what a forcible felony is, to know when and how they can use deadly force to prevent a forcible felony from taking place?
They're going to have a better memory than me. I mean, there are a handful of felonies in Iowa that are considered forcible felonies.
Generally speaking, give us a rundown of what they are.
Murder.
Seems reasonable.
Kidnapping.
Okay.
Sexual assault.
Rape. Okay.
Yep. Burglary in the first degree.
Let's come back to that.
I don't know if arson is.
Yes.
Arson.
And
robbery. And then human trafficking.
Okay.
I think that's it.
We'll fact check that later. But I think you're pretty darn close.
Okay.
Certain assaults, willful injury, isn't it? I bet there's some others.
Might be.
Attempted murder.
Might be. I don't remember.
I got a cheat sheet in the corner over there. Okay. So there are certain things, but even us, we're sitting there going, what exactly is a forcible felony?
Right.
So how's normal Joe supposed to know? And the burglary is breaking into an occupied structure with the intent to either commit an assault or a theft. But first degree, the difference between first and second degree, generally speaking, is what?
The weapon.
So they got to have a weapon. You got to have reason to believe they have a weapon.
Right.
So to say I'm relying on that forcible felony, it's kind of like a oops after the fact situation, right?
Well, and I don't even know if reason to believe they have a weapon would do it. They might actually have to have a weapon. I mean, that's, again, a gray area here. So it's tricky.
It's tricky, and we got 5 minutes left. But we gotta
Let's do this in our 5 minutes. I'm
Yes.
sorry to cut you off.
It's your show.
Let's make sure
It's your
that
show.
people understand when the use of reasonable force is not allowed. Under
Dude,
what
I like that.
circumstances
Yes.
can you not use it?
boom, go.
So you cannot use it if you're engaged in any type of forcible felony. If you yourself are committing a forcible felony, like we just talked about, you don't get a justification defense.
Okay, fair. I'll give them that.
You don't get to use it if you're involved in a duel, the old-fashioned take 10 paces,
Hamilton?
turn around, yeah. And you don't get to use it if you're involved in a riot.
Okay, we have to talk about the riot situation.
Sure. So let's think Washington, D.C.
Yep.
Riots, or whatever you want to call them.
January 6th.
January 6th. I'm there, and it's a peaceful demonstration, right? But it turns, and it starts to get aggressive. And people start to brandish weapons and start hurting people, that kind of thing.
Can I ask a question before we get here?
Sure.
Is it reasonable force, or are we talking deadly force?
Any
Any
use
force.
of force.
Oh, this gets
Any
even
use of
better,
force.
this example.
Any use of force.
Okay.
So I'm there, and this protest has
Clear-
now turned into a riot.
But you were clearly participating in the protest.
Right.
You probably got a shirt, a sign.
Sure. But it's turned into
You're on video protesting.
It's turned into a riot
Okay.
at this point. And one of the rioters takes a gun and is going to point it at a security guard or is beating them with a bat or whatever. And I pull out my gun and I shoot the person who is beating the security guard. Okay? If the conclusion is I'm also participating in that riot, I don't get the justification defense. I don't get to use reasonable force as a defense in that scenario.
What if instead of shooting the guy, you smoke him upside his head?
I still don't think you get to use reasonable force in that scenario because assuming you are actively participating in the riot, then that defense is not available.
And the Iowa definition of a riot,
I don't know that.
we don't. It's a whole different story, but
Right.
it's pretty amazing. So okay, so you can't use it when rioting.
Right.
Okay. When also let's go through the takeaways. When can you not? Go ahead. It's your show.
One other thing, the retreat, the
Yes.
duty to retreat. So
That's important.
If you are involved in a crime and you use force, that duty to retreat, the Supreme Court has said, is still implicit. So you still have a duty to retreat if reasonable, if you are involved in a crime before you're able to.
So if you're
use-
drunken, if we're both drunk in public, as Ron White likes to say, and we're about to fight, you threaten me, and I have a way out, and I don't take that way out,
Then you,
I don't get justification.
correct.
I gotta leave.
Well, the jury would get instructed that if they find that you
Okay.
had a reasonable alternative, to retreat and you didn't take it, then it's not. But it's a jury question. But
Okay.
still, the jury could find, no, you don't get the defense.
So let's throw down on the deadly force. When can you not use deadly, or when is deadly force not permitted? Just so people have this takeaway.
To defend property,
Okay.
if you're involved in a riot, a duel, or a forcible felony, or if you use it to dispel any other type of force where there is no reasonable probability of serious injury or death.
So primarily speaking, you can only legally, lawfully use deadly force when there is a threat of serious bodily injury or death to yourself or somebody else. Is the best way. If you're going to say the most cautious application is this,
Yes.
it would be that.
Yes.
And let's be honest, once you pull the trigger,
You can't put the toothpaste back in the tube.
you can't. You absolutely can't. And then what's going to flow from that, which is kind of my biggest concern, is there's a lot of people that almost feel are looking for justifications to use lethal force without truly appreciating what it means and the toll it takes to be the person to take somebody else's life.
Yeah, absolutely. I mean, that's why I said it's a tricky doctrine, and the stand your ground title that it's been given doesn't accurately portray what the law truly says.
It's a complicated, convoluted spreadsheet.
This is the decision-making process you have to go through before you pull the trigger.
Well, that's why we got the wolf. Why didn't you tell me you called the wolf?
Should have called the wolf.
Hey, appreciate the time. We're going to come back with the do's and don'ts with Donut. As always, crush it. Thanks, boss. It's your show.
All right.
We are back with do's and don'ts with Donut.
Yes, we are.
Justification edition.
It's not Justification edition, though.
Is it Wolf?
No, it's, I read this one and I was like, I wonder how many times we get a call asking a question of similar nature. On like a weekly basis. Maybe not weekly.
Does it involve
Bi-weekly?
Does it involve knives?
No.
Trash bowls.
No.
See, I got it in. Boom. Okay.
Just drugs and alcohol.
Perfect.
Yeah.
Let's go. Roll with it.
All right, title. I know it's stupid, but please help. Also, probably the first sentence in the phone call.
Self-explanatory.
Yeah. I'm on United States pretrial release for a federal drug case. I caught a case in 2021, and I'm about to be sentenced to a very hefty amount of time on the 30th of May. I haven't done any drug or drank alcohol or done anything to violate my pre-sentence or pretrial sentence since I've been on it. I kind of want to smoke some weed and maybe drink a beer or two before I go to prison. How would this affect my pretrial or affect my sentence, which has already been agreed upon by my defense team and the United States District Attorney? Would I get a violation, or is this just kind of stuck in time with the sentence they've agreed upon? Would they be able to re-sentence me after I'm in custody? Any help would be super cool. Thanks, people. I saw this and I thought, you know what? It's gotta be a topic of conversation that's happened quite a few times among the years around here.
Do you want to know the worst feeling going into a federal sentencing?
You know that they're going to prison for longer than Donovic?
That's part of it. You want to know the worst feeling?
What?
Is when the judge, right before sentencing, says, "May I see counsel in chambers?"
Uh-oh.
And pretrial release is standing right there with the judge. And they say, "The defendant tested positive for marijuana this morning because we dropped them before sentencing."
Yep.
And you go, shit.
Yeah.
So, kudos to this individual for asking first.
Yep.
We always like to give positive reinforcement. This person does have an attorney.
That they could ask.
Should ask.
Should. Yes.
But Donut, do help.
I have a different answer than you.
Oh, okay.
Sometimes I think it's better to not ask questions and say sorry later. And I think it might bite you in the ass if the judge finds out that you asked Reddit if you could get high and get drunk. And they somehow figure out that not only did you get high and get drunk, but you pre-planned it.
Fair.
If you're going to do it, do it. It's not
Don't
going
ask
to
first.
be pretty, but don't ask for permission.
Ask for forgiveness, not permission. That is quality advice. The other thing is, absolutely, this will bite you in the ass.
It will.
The plea agreement, I promise you, it's the federal government you're entering into a contract with. And the federal government is going to have a provision in that plea agreement that says this plea agreement is conditioned upon no further offenses by the defendant between now and the time that they are sentenced.
Yep.
And so if you go and you smoke the weed and you get drunk, that is an additional violation of law, believe it or not, and a violation of your pretrial release conditions that could, if the prosecutor wanted it to, invalidate the plea agreement.
Yep.
Additionally, if it's not a type of a plea agreement that the judge binds themselves to follow the plea agreement at the time the plea is entered, the judge always has discretion to accept or reject the plea agreement and sentence that person to however they see fit.
And also make you drop before they make the decision.
And if you're on federal pretrial release, they drop everybody before the sentence takes place.
Interesting.
Everybody. Every single person.
So this is a really bad idea.
This is a horrible.
Bad idea in state court, but they're probably not going to drop you. We're probably going to tell you to sit down, shut up, and pray to God the whole time.
I get it. I
Yep.
understand it. And unless you're going in to be sentenced to the maximum, no, don't do it. Because you walk in, before you walk in for your sentencing in federal court, you go and you visit. If you're out of custody, which I'm impressed, this person is going to have a hefty
Amount of time out of custody.
for a drug-related offense
Yeah.
in federal court. You did something.
Yep.
To get yourself in that position. Don't screw it up.
Yep.
And
hide your papers.
Fuck.
Fuck.
don't let your fellow inmates see your docket sheet.
Yep.
Yeah, well, that's another discussion. But before you get sentenced, you march yourself to pretrial release, probation department, and they do a urine test. They drop you before sentencing, and then you show up at sentencing, and then the pretrial release guy or gal goes up and reports to the judge whether there's been any violations or not. And then if you get the, excuse me, may I see counsel in chambers beforehand,
That's when you know.
you're like, oh, son of a bitch.
Interesting. I did not know they
Yes.
dropped everyone before.
They do.
No one told this man that in the comments. So.
In federal court, they drop everybody that's out of custody before. You could be being sentenced for fraud, not drug related. They're going to drop you.
Huh.
How's that?
Someone could have been saved by this question.
They-
This might be the first one where we've had absolutely no, this is a terrible idea.
I think we can definitively say do roll with it if you're gonna. The agreement is to be sentenced to the maximum.
Yeah, if you're getting sentenced to the maximum, I mean,
Go down. Screw it.
I mean, even if you're not getting, I understand.
Actually, let me retract. I'm retracting.
Yeah.
On the record.
Okay.
Don't do it. It's against the law.
Yeah.
Okay. But I think we could say, don't.
Do not.
Do think about it.
Yeah.
Do ask questions. Do ask for advice on this issue. Ultimately, the 1,000% answer is
You're going to have consequences more than likely for your decision. And with that,
don't do it.
don't do it, or do, but at least
Understand.
go into it with the knowledge that you're going to face consequences. And if you decide that you need to,
If it's worth it, it's worth it. That's your decision, but
nah.
don't.
Yeah.
That's a good one.
Yeah. I know. I'm sure you get this call more than. And you know what? If you don't get this call, then it's because they're not calling. So, and they took my first advice of maybe just
Don't.
pretend like it was an accident.
Do ask questions.
Yeah.
Don't do it. Don't break the law.
No.
Don't get yourself extra time. Because also if you show up in federal court high and drunk, I
It's
think
not the place you want to be in the first place. So it's definitely not the place you want to.
be publicly intoxicated.
Yeah, for sure.
That's a good
Cheers.
one. Cheers. Till next time. Thanks all.
We can't change the past, but we will change your future. GRL Law. Thanks for tuning in to GRL Raw. Check us out at grllaw.com.